Good day, sir. I'm Angelica Pagkaliwangan of 4G1BS Criminology. So, I am discuss the Rule 119 to Rule 126 on what I have learned and what I have understand. So, first is Rule 119, which is trial. So, trial defines the examination before a competent tribunal of the facts put in issue for the purpose of determining such issue. The trial shall commence within 30 days from receipt of the pre-trial order in Rule 119, Section 1. On continuous trial, trial once commenced shall continue from day to day as practicable until terminated. Um, Period for rendition of judgment. Trial courts must be their judgment within 90 days counted from the time of submission of the case for decision or resolution. So for the period of rendition of judgment on trial, you must be give the judgment within the 90 days counted from the time of the submit the documents or the cases for the decision. So, Section 3, Exclusions. Delay resulting from an examination of the physical and mental condition of the accused. So, delay resulting from proceeding with respect to other criminal charges against the accused. So, in Section 3, Exclusion, the accused examination before the entering of the jail must be examination the physical and the mental condition. In order of trial, the accused may present evidence to prove his defense and damages in any arising from the issuance of provisional remedy in case. So, in order of trial, the accused may execute the present evidence to defense himself. RA 6981 State Witness. The offense in which his testimony will be used in a grave felony as defined under the Revised Penal Code or its equivalent under special law. Reason, to prevent dilatory tactics of defense lawyer. Some of them file this purpose of delay. In Rule 120 judgment, the judgment is the adjudication by the court that the accused is guilty or not guilty of the offense charged by the imposition on him of the proper penalty and civil liability. It must be written in the official language personally and directly prepared by the judge and signed by him. So, in the judgment, the accused, the both parties execute each other complaint. The court by the judge this guilty or not guilty, and after it must be written the official language of the each other penalty preferred by the judge. So, formula for conviction is first the crime committed plus evidence to prove equals conviction. So, promulgation of judgment. It is the reading of the decision of the court in criminal case in the presence of the accused. Modification of judgment. A judgment of conviction may, upon the motion of the accused, be modified or set aside before it becomes final or before appeal is perfect. In entry of judgment, after a judgment has become final, so it shall be entered in accordance in Rule 36. So, in Rule 121, the new trial or consideration at any time before a judgment of the conviction becomes final, the court may be on motion of the accused or at its own instant, but with the consent of the accused, grant new trial or reconsideration. So, if the accused cannot defend himself, maybe grant a new trial or the reconsideration. So, new trial whereby the accused on his own motion or the initiative of the court, but with the consent of the accused. Present of the accused allowed to present additional evidence in support of his defense after a judgment of convictive has already been. Next is requisite of newly discovered evidence. So, the evidence was discovered after the trial. So, it could have been discovered during the trial. It is trial, not merely corroborative, cumulative. It would probably change the judgment. So, in the requisite of newly discovered evidence, the evidence was discovered after the trial. So after the trial, the evidence was determined, execute. So example, incompetence of counsel or neglect. Improvident of plea of guilty or retraction of witness. Errors of law, a mistake by the court as interpretation and application of the law. So, Rule 124, procedure in the Court of Appeals. Appellant or appellee. In all criminal cases appealed to the Court of Appeals, the party appealing the case shall be called appellant and adverse party by the appeal, but the title of the case shall remain as it was in court of origin. Appointment of counsel de officio on appeal. So, the accused is confined in prison, is without counsel. The party on appeal has signed and notice of appeal himself. So, in the appointment of counsel de officio on appeal, which is the accused is confined or convicted in prison. Speedy from disposition of appeal. Appeal of accused who are under detention shall be given precedence in their disposition over other appeals. Speedy or from disposition of appeal. From the word speedy, the appeals of the accused to speed or the past process. Rule 125, procedure in Supreme Court. So when the Supreme Court is equally divided in opinion, or the necessary majority cannot be had on whether to acquit the appellant. So, um, appellant. So, the case shall again be deliberated upon, and if no decision is reached after the deliberation, so the judgment of conviction of the lower court shall be reversed and the accused um, acquitted. Rule 126, search and seizure. Search warrant is an order in writing issue in the name of the people of the Philippines, signed by the judge and directed to a peace officer, commanding him to search for personal property described therein and bring before the court. So in search warrant, in order to writing issue by the name of the people and signed by the judge, and commanding him to search for personal property and describe wherein and bring it before the court. Property that may be seized. So, subject of the offense, stolen or emblazed and other proceeds or fruit of the offense, or used or intended to be used as the means of committing an offense. So, in property that may be seized, indicate the subject of the offense, the use or intended to be used by the means of committing an offense. Requisites for issuance of search warrants. So, yung mga requisites for issuance of search warrant is there a probable cause and in connection in one specific offense and personally defined by the judge. So, it's only the judge to determine to create a search warrant if there have a probable cause. So, witnesses in search, no search of a house, room, or any other premises shall be made except in the presence of the lawful occupant thereof or any member of his family, or in the absence of the latter, two witnesses of sufficient age band discretion residing in the same locality. So, time of search, the warrant must direct that it be served in the daytime, unless the affidavit assert that the property is one person or in the place order. So, the time of search of the warrant must be daytime. So, validity of search warrant shall be valid for 10 days from its date. Receipt of seized property. The officer seizing the property under the warrant must give a detailed receipt from the same to the lawful occupant of premises in those presence the search and seizure were made. So, receipt of seized property indicated the detailed where the officer search. So, search incidental to lawful arrest. A person lawfully arrested may be searched for dangerous weapons or anything which may have been used or constitute proof of the commission of an offense without a search warrant. So, yung mga accidental to lawful arrest po, yung mga person may be arrested in a dangerous weapon, like hostage, hostage, kidnapping, etc. General rule. A law enforcer cannot search another without a search warrant. So, search incidental to a lawful arrest, search of moving vehicle, seizure of evidence in plain view, search in connection with enforcement of custom law, consented search, search in state borders, search in emergency circumstances, and staff and risk. The general rule, the law enforcer too cannot search another without a search warrant. Next is general search warrant. A search warrant which describe and does not particularize the personnel properties of the siege without guidelines as to what items might be lawfully searched. Fruit of the poisonous tree. A doctrine which says an unlawful search trains not only the evidence obtained threat but also facts discovered by the reason of said unlawful search. Miranda Doctrine, a rule announced by the U.S. Supreme Court in Miranda versus Arizona and adopted by the Philippine legal system, which requires the police officers to inform the person arrested of his rights. So before the person arrested, the Miranda Doctrine said of the police officer. Next is subpoena, a process directed to a person requiring him to attend and testify a certain hearing or proceeding. So in the subpoena, this is the process to directed a person is to inform him to attend and to testify himself and defend himself. And bench and bar. Bar refers to the legal profession of or all lawyers, and bench refers to the judges or justice. That's all, sir, and thank you.